Go morning class. Welcome to today's explainer session. I am your professor, and today we are strictly focusing our attention on a highly anticipated fundamental 16-mark question for your upcoming KSLU final examinations. Right, so our topic is question 28, define trust, compare it with debt, ownership, bailment, agency, and contract. Now you need to pay very close attention today. We're going to dissect the bare act, break down the mandatory case laws, and learn exactly how to format your answer script to secure maximum marks. Okay, let's dive right into this.
Here is your answers synopsis. 1. Introduction. 2. Definition under Section 3. 3. Essential elements of trust. 4. Comparison with other concepts. 5. Key features of trust. And 6. Case laws and conclusion. Now you must draft this exact synopsis on the very first page of your answer booklet to immediately command the KSLU evaluator's attention.
Let's start with heading number 1. 1. Introduction. Go ahead and underline this twice in your exam script.
A trust is a fiduciary relationship where one person holds property for the benefit of another. It is governed by the Indian Trusts Act 1882. Now, don't just write that a trust is a relationship. You've got to deliberately emphasize this foundational statute. Every single competent law student must cite the Indian Trusts Act 1882 right at the beginning to anchor their answer in statutory law.
Moving on to heading 2, definition, section 3. Let's look at the statutory definition, which absolutely demands your precision and memorization.
The exact wording from Section 3 reads, an obligation annexed to the ownership of property, arising out of confidence reposed in and accepted by the owner for the benefit of another or of the owner and another. Okay, let's academically dissect these scoring terms, shall we? Obligation annexed. This literally means the duty is irrevocably attached to the property itself, not just the person. And confidence reposed? Well, this is the absolute bedrock of equity. The settlor places absolute faith in the trustee. You have to write these exact phrases. Examiners are actively scanning your paper looking for obligation annexed and confidence reposed.
Next up, heading 3, essential elements of trust. Prepare yourselves for a numbered list which must be replicated perfectly on your paper. There are 5 non-negotiable pillars of a trust. Number 1, author or settlor creates trust. Number 2, trustee holds property. Number 3, beneficiary for whose benefit. Number 4, trust property. And number 5, lawful purpose. I'm warning the class right now. Omitting any single one of these elements will result in severely deducted marks. You simply cannot have a trust without trust property, just as you cannot enforce a trust created for an unlawful purpose. Write all 5 down, clearly numbered. Let's move to heading 4. 4. Comparison with other concepts. This comparative analysis segment forms the substantive body of a top-tier 16-mark response. Draw this exact table. Let's look at trust versus debt. When we look at the basis of nature, a trust is a fiduciary obligation, whereas a debt is strictly a monetary obligation. In terms of ownership, the trustee holds property in a trust, but in debt there is no property transfer. For relationship, in a trust it's between trustee and beneficiary, unlike the simple debtor-creditor dynamic in debt. Finally, regarding duty, a trust imposes a strict fiduciary duty, while debt involves only a repayment duty. So what's the core takeaway here? A debt is merely about money owed, right? But a trust involves actual property held under a sacred fiduciary confidence. Moving to our next table, trust versus ownership. Let's examine the basis of control. In a trust, it is divided between trustee and beneficiary, but in sheer ownership, control is absolute. Looking at the benefit, a trust exists strictly for the beneficiary, whereas ownership is strictly for the owner. And by nature, a trust is fiduciary, while ownership is proprietary. Here's a crucial KSLU exam technique for you. Brilliantly illustrate this contrast on paper. Show the evaluator that you completely understand the divided control of a trust, where legal title is totally separated from equitable benefit, as opposed to the absolute, undivided control of sheer ownership. Next up, we contrast trust versus bailment. Regarding the basis of property, a trust involves true ownership, while bailment is merely only possession. The purpose of a trust is for the continuous benefit of the beneficiary, whereas bailment is always for a temporary purpose. Finally, the duty in a trust is strictly fiduciary, while in bailment, it is purely contractual. Listen,
Evaluators actively look for this specific distinction. In a trust, the trustee actually becomes the legal owner of the property, but in bailment, the bailee merely holds physical possession. Do not confuse the two. Table 4 covers trust versus agency. On the basis of function, a trust holds property, but an agency merely acts on behalf of another. Crucially, regarding ownership, in a trust it vests in the trustee, but in an agency it remains with the principal. As for duty, a trust is a strict fiduciary obligation, while agency is fiduciary but limited. Now, this is a classic trick question. The examiner wants to see if you actually know that ownership vests entirely in a trustee, whereas an agent merely represents the principal, while the principal retains full ownership. Definitely mark this distinction as absolutely essential. Our final comparison, trust versus contract. By nature, a trust is an obligation annexed to property, while a contract is fundamentally an agreement between parties. Looking at formation, a trust requires confidence plus acceptance, whereas a contract is born from offer plus acceptance. For enforceability, a trust is enforced by the beneficiary, but a contract is enforced by the contracting parties. And most importantly, regarding consideration, in a trust it is not necessary, but in a contract it is essential. I'm really stressing this critical exam point, class. Consideration is the absolute lifeblood of a valid contract, but it's entirely unnecessary for the creation of a valid trust. Make sure you write that down.
Okay, moving on to heading 5. 5. Key features of trust.
We've done the heavy comparative lifting. Let's summarize the core legal philosophy of a trust before we jump into our case laws. The key features are based on confidence and fiduciary duty, trustee must act in good faith, and beneficiary has enforceable rights. I strongly advise the class that writing these exact phrases demonstrates a really mature, sophisticated grasp of equitable principles. It shows the examiner you understand the spirit of the law, not just the mechanical rules.
Now for heading 6. 6. Case laws and conclusion.
Class, sit up straight and command your absolute focus right now. Memorizing the statute is expected, sure, but correctly citing mandatory precedents? That is exactly what separates an average passing student from a university rank holder. Our first mandatory citation is CIT v. Camalini-Catau. Explained nature of trust and fiduciary relationship. You've got to know the context here. Briefly, the facts revolved around the taxation of trust income, where the beneficiary's shares were totally indeterminate, which questioned the very role of the trustee in managing those assets. So, what did the court say? The Supreme Court's final ratio decidendi firmly established that a trustee doesn't hold property for themselves, but acts as a mere conduit, strictly bound by a fiduciary bond to the beneficiaries. This case is incredibly relevant because it solidifies the absolute foundational bedrock of equity in Indian law, that legal ownership by a trustee is purely administrative, not absolute. I'm instructing you right now, draw a distinct, clean box around CIT v. Camalini-Catau on your exam paper. Highlighting this case clearly tells the KSLU evaluator that your foundation in case law is rock solid.
Our second mandatory precedent is State of UP v. Bonsithar, clarified obligations of trustee. The facts of this case centered around a charitable endowment where the funds were basically at risk of being misappropriated, calling into serious question the strict duties of the state when acting in a fiduciary capacity. The court's verdict ruled that anyone stepping into the shoes of a trustee is strictly bound to execute the trust according to its exact intent, without any deviation whatsoever. Its absolute relevance lies in defining the rigid, uncompromising boundaries of a trustee's conduct, proving that the obligation annexed to the property is inescapable. When you write State of UP v. Bonsithar in your exam booklet, I want it heavily underlined. It is the definitive authority on how a trustee must conduct themselves if you want to secure a top-tier score.
Finally, we reach our conclusion.
Class, I must remind you that a perfectly structured answer script is completely incomplete if it just trails off at the end. You must always finish with a strong, decisive concluding paragraph. To conclude your exam, write this exactly. A trust is a unique legal relationship combining elements of ownership and obligation. Unlike debt, contract, or agency, it imposes a strict fiduciary duty to act in the best interest of the beneficiary. Memorize it, write it flawlessly. By proving that you can distinguish a trust from every other commercial arrangement through the lens of strict fiduciary duty, you essentially prove you are ready for the legal profession. As we end this explainer lecture, I want to leave you with one final provocative question to think about. When you finally step out of this university and into the real courts, how do you, as future lawyers, intend to uphold such strict fiduciary duties in your own legal practice? Thank you, class, and best of luck on your examinations.